Hello, everyone. Thank you for joining us today for the webinar about the Provisional Unlawful Presence Waiver. I'm here today with Morali Basham,
Hi, Amy.
and we're going to get started now. So I think today we're going to talk about, just in general, what is this Provisional Unlawful Presence Waiver? How is it different from what we've had before? What are the guidelines for eligibility, the procedure for filing, and just some general thoughts about case preparation. Okay, so the provisional waiver is actually rooted in a waiver that we already had. It's a new process, but it's the same law. So the best way I know how to explain this is to give you a sort of probably what the most common fact pattern is for this kind of case. So let's say someone entered the U.S. without inspection. This person marries a U.S. citizen. This person would like to have a green card. So the problem here is that the person can't file all of the green card paperwork here in the U.S. because what would happen is the person would be scheduled with his or her U.S. citizen spouse for an interview, and at the interview, they would have to prove that they entered the country legally, even if they overstayed, but they have to prove they entered legally. So if this person entered without inspection, they can't do it. So their only option is to do a different process where it results in the foreign relative returning to their home country for an interview. Now, the problem there is that the minute the foreign relative leaves the U.S., they trigger, most times would trigger a 3 or 10-year bar to coming back to the U.S. So it's sort of like a double whammy. You can't file all the green card paperwork here in the U.S. because the foreign relative didn't enter the country legally, but then when they try to do things the right way and go back to their home country, boom, they trigger this 10-year bar to coming back.
Amy, what's the difference between a 3 and a 10-year bar as far as how you trigger that?
Well, it depends on the amount of unlawful presence. And the problem with just the word unlawful presence is it's a legal term and it has a very specific definition. So it actually doesn't mean like every day you're here unlawfully, even though you think it would. So for someone who triggers a 3-year bar, that's someone who's been in the U.S. and accumulated 100 or more than 180 days of unlawful presence. Someone who is triggering the 10-year bar is someone who has been here and accumulated more than a year of unlawful presence. Okay, so the only way to get around this bar is to file an application to waive this ground of inadmissibility. So the regular process is still in place, and the regular process that we've had to work with for all of these years involved preparing the waiver application, just like with the new process. But the problem is that the foreign relative had to return to their home country and file it. So they never really knew, um, if the application was going to be approved or not. They never knew how long it was going to take. In some places, I mean, it could take a year easily.
So I guess the process is first file an I-130 with the Immigration Service,
Right.
and then that has to be approved,
Right.
and then it goes to consular processing, and then they would have to leave and file the waiver application in their home country.
That's right.
And there's always that risk that that gets denied and they get subject to these bars and they get stuck. Right, Amy?
Right. It's stuck for the whole length of the time of the bar. I mean, I've seen many people who filed their waivers on their own and got denied. Okay, so the thing about the new process is, the great thing about the new process is that the waiver application, which is the hardest part of all this, is filed in the U.S. before the foreign relative even gets on a plane. So the idea is that when the foreign relative, leaves the country, he or she has some confidence that they're coming back. I mean, it's provisionally been approved, so they've looked at the merits of the waiver application, and they have, approved it. And also, it should really shorten the time spent in the home country. I mean, I would say that the idea is they should only have to go home for a couple of weeks to do the interview, get a medical exam, and then return.
I mean, does it take really a lot of the risk out of it? Let's say that I'm approved for a provisional waiver here in the U.S. I have to go back to my home country for consular processing, finish that last stage of the process. Should I feel pretty good that everything's going to be okay at that point?
I think you should, but at the very end of this PowerPoint, there is a frequently asked question because I get that question all the time. And the thing is if that's the only issue with someone's case, then I think they should feel reasonably confident that they're coming back. I mean, of course, if you're listening to this webinar and you haven't filed your provisional waiver application yet, then you're not part of the first wave of people who are filing. I mean, the filing for these provisional waivers just opened March the 4th. So we're going to see over time from the first batch of people who filed, what their experience is when they go back to their home country. But now, if someone has some other issue, like, let's say they have a criminal conviction, I mean, that the provisional waiver doesn't cover that, and that's going to be a problem when they return home.
It only covers the unlawful presence, right?
Right, that's right. So whoever files a provisional waiver, they have to make sure that the case has been analyzed very well and that they have a very clean case other than the unlawful presence. Okay, and so yes, on this slide, I made a slide just to point out that it only waives unlawful presence. It doesn't waive any kind of criminal issues or fraud or anything like that. Okay, these are the general guidelines. I haven't put every guideline that's listed in the materials from the Immigration Service, but I put the most common things. Okay, so one thing about this waiver is the foreign relative has to be the spouse, child, or parent of a U.S. citizen. So in the regular waiver process, this also works if the foreign relative is the spouse or parent of a permanent resident, but it does not work for the provisional waiver. Okay, there has to be an I-130 that's been filed and has been approved. In this process that results in having an interview in your home country, after USCIS approves the I-130, the USCIS forwards it to the National Visa Center. National Visa Center is the office that's responsible for getting the file ready for an interview. So they will send out a bill for the visa fees. Of course, the government wants more money.
Of course.
And you have to pay that and actually print out your receipts and include those in the waiver application. The foreign relative also has to be physically present in the U.S. when the waiver is filed, and they also have to give biometrics. And then the foreign relative has got to provide evidence that his or her U.S. citizen spouse or parent will suffer extreme hardship if they're not allowed to get a green card. And it's important to point out here that you don't see children listed because children are not considered. It has to be hardship to a U.S. citizen spouse or parent. So if you're talking, if you're preparing a waiver and you're discussing U.S. Hardship to a U.S. citizen spouse, if there's some way to connect hardship to a child resulting in hardship to a spouse, you can do it that way. But you can't have a separate section of your waiver application that talks about hardship to U.S. citizen children. The other thing about hardship is there's not really a good definition of what extreme hardship is. I mean, we know that any family is going to suffer if they're split up. So, for extreme hardship, it's got to go at least a level beyond what any family is going to suffer if they're separated.
And I guess going back to the whole unlawful presence idea, I guess a child under the age of 17 couldn't do a provisional waiver, right?
That's why I didn't put that requirement down.
Yeah.
Is that weird? Because one of the guidelines is you have to be 17 years old, but it doesn't even make much sense
Right.
to me to discuss that because that's going to be so unusual. But the bottom line is anyone who's considering filing, they need to talk to an attorney. They need an attorney to analyze their case because I haven't listed every single requirement. This is just a broad overview of what the requirements are. Okay, as far as the procedure goes, so this starts out with filing an I-130 immediate relative petition. This is what anybody files that has a foreign spouse in another country. This is how it all starts. So the I-130 probably is taking it's a little bit on the long side now, about 6 or 7 months. Once the I-130 is approved, the Immigration Service forwards it to the National Visa Center, as I mentioned before. The National Visa Center sends the bill for the visa fees. You got to pay those fees, and then that's when the waiver is filed. After the waiver is approved, assuming it's approved, the Immigration Service notifies the National Visa Center. Now, if your case is completely ready, at the National Visa Center, you've given them all the forms and documents they need, then they'll go ahead and schedule an interview. But if it's not, then at that point, you need to finish doing, you need to give National Visa Center whatever they're waiting on so you can get the interview scheduled. Once the interview is scheduled, the foreign relative is going to go back home. They got to get a medical exam done. They got to go to their interview. And if everything goes well, usually the immigrant visas are issued about a week or so after an interview. And then they use that to return to the United States. And on the first day the relative steps foot on U.S. soil, the relative is a permanent resident. Sounds simple, huh?
I was
But
just about to say that.
here's the hard part. So I wish I could show people out there what a waiver looks like, because I think it's probably hard to have a concept of what the waiver package is. But usually it's very large. It all centers around an affidavit from the U.S. citizen, and this is where the U.S. citizen is detailing all the hardships and how extreme these hardships are. It's everybody's affidavit is different. They're all completely different, and the degree that you have to explain hardships and talk about someone's background, it just varies. Like, for example, I had a client who he had a lot of painful separations from close relatives when he was a child, and he was going to see a therapist about that. But I felt like because of what had happened to him as a child, it made his hardship a lot worse as far as the emotional separation from his spouse. But I felt that in his affidavit we had to go back and tell the story of his childhood and the separation from his mother and his father and all of that. So it made his affidavit very personal and probably much more detailed than some of the others that I've done for that
Let me ask you a question. In the 601 cases you've done, do you ever have a situation where someone comes in and says, well, the hardship obviously is just a separation from the spouse, and they don't really think they've got anything outside of that, but once you really dig into it, they do?
Oh, all the time. In fact, over the years, I've made a checklist for myself. I don't give it to clients. It's my own personal checklist. But this is the way I make sure that we've thought about everything in the kitchen sink. So ours is one of the first things we do. Really, it's even for the hirer, because this helps me get an idea of what we've got to work with. We go through my checklist and come up with all the grounds of hardship we can think of. And sometimes there are things that come up as we work on a case. I didn't realize that it was going to be a hardship in the beginning, but as I get to know the client better, I realize, yes, something truly is. So let's see. These are just some of the basic grounds of hardship. People aren't going to one particular hardship in a case. For example, if someone came in and they were quadriplegic. Yes, that's one major hardship that's going to win a case. But usually it's a combination of factors. So I always start out asking about the U.S. citizen's health. Has the U.S. citizen had a major illness? Do they have a disability, even a learning disability? That was one thing in one case we worked on. The client didn't even realize he had a learning disability because he wasn't able to finish school in his own home country. So he couldn't speak write his own language well, or English. And I didn't think much of that until I got to know him. And then I suspected there was a little more to it. So we sent him to a professional who specializes in diagnosing learning disabilities. And, it turns out he did have a learning disability. It's hard to say what part that played in the case, but I do think it helped. Mental illness, emotional hardship. I always ask the client, have you ever been on antidepressants before or anti-anxiety medication? And the reason I ask that is because I think that if someone has struggled with depression or anxiety in the past, that's someone who is prone to possibly experiencing those feelings again. I'm not a mental health expert, but those are little clues that tell me, maybe this person should go and just talk to someone, a professional, and see.
I don't know, Amy, you sound like a mental health expert right now, the way you're describing all of this.
That might have been my second occupation if I hadn't been a lawyer. Who knows? But that's one reason why I like these cases, because I really do get to know people on a much deeper level than a typical kind of case. Also, if the U.S. citizen has family members that they're responsible for, aging parents, or a parent who has Alzheimer's, or a parent that can't get out of the house and they have to go to the grocery store for them every week. Children. So children from a prior relationship, that's in some ways a little easier to use because there's most people who are sharing custody. There's no way in the world that the father, who's not the foreign relative, but the father of the children from a prior relationship, or mother, is going to let those kids move to another country. So that's kind of an easy way to talk about, well, that there's no way possible the U.S. citizen can relocate to Mexico or Honduras or wherever it
Or if
is.
there's a child support payment and they're going back to an economically,
Right,
bad country.
right, something like that. Um, the children from the current relationship, or really either relationship, like we've had cases where children had disabilities, and it just wouldn't work for them to go back to the home country because they couldn't get the medical care they needed there, or the educational opportunities to deal with their learning disability or something like that. U.S. citizens' family ties to the U.S. I never thought that this was going to be that strong until I had one case where I found out that my U.S. citizen, he lived within 2 miles of 5 brothers and sisters. And I was like, bingo. And so I actually printed out a map, and I drew, I drew little arrows, and I plotted out each relative, where each relative lived on the map, and I even include evidence of their driver's license and their birth certificates to prove that was really the brother or sister, and to prove where they really lived.
So if you took this person out of that type of familial situation, that would cause hardship?
Well, yes, because he had,
It's a support system, is what you're
yeah, and
saying.
he was, you could just see from that he was much more close to his relatives than maybe some people are. But he also had no relatives in the foreign spouse's home country to go to. Economic hardship. Now, this in and of itself is not going to be enough to win a case. But, let's say that the foreign spouse is the breadwinner of the family. Also, what if the U.S. citizen owes money, school loans, credit card debts, car loans? You can't just walk away from that and move to another country.
I guess if you looked at the world now, if economic hardship would do it, pretty much all of these cases would get approved.
Well, maybe. Maybe. Spiritual, this isn't one that I'm usually able to use, but if it's impossible or very impractical to practice your religion in the way you practice it in your spouse's home country, that's something else. For example, if you're a Christian and your spouse is from Bangladesh, you're going to be like 1%, and it's pretty well known that they're persecuted there. So that's one example. Um, Country conditions in the foreign national's home country, and since a lot of these cases are for foreign relatives who are from Mexico, with all the crime that's been reported in Mexico, there are just tons of reputable sources to use for these reports, U.S. government sources.
So when you go through all of these factors, you're trying to analyze a case, and somebody says, well, I think I've got X and Y,
Mm-hmm.
and they ask you, well, what's enough? What do you say? Like, what's enough? Is it just health and family ties? I mean, what in your opinion makes for a good case?
It's very hard for me to answer that question because it really just depends on the
The
case.
totality of the circumstances, I
Yeah,
guess.
but before this process started, when the risk is the person is going to go back to their home country, we don't know if it's going to get approved. It's hard to look anybody in the eyes and say you got a good case. A lot of our clients, in fact, from who processed in the old way, came to us because the foreign spouse went home before they even realized what a nightmare it was going to be. So they had no choice. We did have some who thought hard about it, and I would usually make people like go home, think about it, come talk to me like 2 or 3 times before I would even take their case, because I wanted to know they had really thought this through very
But now
well.
that there's less risk,
Yes.
you know.
Now there's so much less risk. I think that probably the number one question is, whether or not to file is a financial consideration. Do you have the money to file? And also not to file hastily, to make sure you put together the best case possible, and there are no other, factors that are going to mess you up somewhere along the way. Okay, and the other thing, an affidavit from the foreign relative, Sometimes I include this, sometimes I don't. It just depends. If it's a situation where someone came to the U.S. as a kid and it wasn't their decision, then I always include that because it wasn't their choice. And whether legally it's technically it's not relevant, but I just can't help but think that if you're reading this, you're going to be more sympathetic if you realize that the person didn't have much of a choice in the matter. Okay, now as far as the affidavit goes, you discuss all these grounds of hardship, but you've got to back it up. So, for example, everyone tries to use mental hardship and psychological hardship. You can't just go to a therapist one time, have them write a letter, and think that's going to work. It's not. I mean, you have to go to someone over the course of, weeks, months, many visits. They have to get to know you well so they can form a professional opinion as to whether or not you're going to suffer extreme hardship. And so you would want to get an evaluation eventually, but the evaluator, the therapist, or the professional, I mean, it needs to be someone who really lists out how well they've gotten to know you, how many times they've met with you, that sort of thing. If it's a physical disability or something like that, of course you're going to need reports and evaluations and doctor's letters, that sort of thing. Any evidence of debts, the country conditions reports, that all that has to be from reputable sources, and the U.S. government puts out a lot of country condition reports, and I like to use their own sources. Um, the letters and affidavits from others, those really have to be carefully tailored. It is not going to help a case just to have someone write that you're a good person and that your U.S. citizen spouse is going to really, you know, be suffering if you're gone. They have to explain why. And so if it's a situation where someone is, let's say they have a physical disability, but it's not something that's readily apparent, like someone who has maybe an arm injuries or something like that. They're on workers' comp, they were injured at work, they have some kind of arm injuries, but they can't lift their child, they can't do housework, something like that. You can include affidavits from other people who have seen how this person has problems with mobility and getting around, that sort of thing.
And the number of affidavits, I guess, just depends on the case.
Right. Yeah, I mean, when we do affidavits, they are very carefully tailored. I work with the client to figure out, okay, who's in your life who has something who can contribute to these hardships, and then we ask them a set of tailored questions so we have the information directed. It's right on point. It's just not all over the place. Family photos, I think those are very important. In fact, I usually pick out the very best photo and I put it in the front of the application, close to the front, somewhere where the officer has to keep flipping by it every time he opens the case.
That's some strategic lawyering there, Amy.
I know. And then I go through the family photos and pick out, other photos that I think are appropriate for the case, and I include those as well. But this is not by no means a list of all the evidence that you can include. These are just some ideas. So Morale already asked the first question that we are getting asked a lot, and does this mean that if you get the provisional waiver approved, are you definitely going to get approved? Well, no. I mean, there's a couple of things that could happen. What if the foreign relative committed fraud somewhere in the past? What if the foreign relative is subject to the permanent bar, and that's a situation where the person came in illegally, left, and came back? I mean, that can be a problem.
So you're just talking about analyzing every other ground of inadmissibility in the case, or potential inadmissibility.
Right. But if you've analyzed it up one side, down the other, and you can't come up with anything, then it would be some big surprise that were to happen at the interview that no one was expecting. What happens if the provisional waiver is denied? So people are worried about that. And again, that's another thing we're going to see as the first wave of people, as those cases go through, we'll see what happens. But the Immigration Service has said that their intent is not to go track down folks who are denied and deport them. Now, that said, if you're someone with you've got serious criminal convictions and you're, in the sort of the group of folks that they would be trying to deport anyway, then yes. But just for the regular average person who doesn't have that kind of criminal background, if they file and it gets denied, I do not believe that the government's going to try to enforce the bill.
I don't either. I think they're safe on that front. But it goes back to what you said earlier, which is it's really important to have your entire situation analyzed carefully before you even file an I-601 waiver.
Right. And there are a couple of other issues for these waivers as well. The first one has to do with if you've already had an immigrant visa interview scheduled, even if you didn't go. And I think this is actually going to be a lot of people's issues because there are a lot of folks who started the process years ago, not realizing really that they couldn't get all the way through it. And they started, got to the National Visa Center, they paid them money, they sent in documents, got scheduled for an interview, and realized, uh-oh, I better not go or I'm going to be subject to the 10-year bar. I mean, we've had clients in that situation before. So, in fact, one of them came to us. They'd already been scheduled for an interview, but they canceled it once they realized that they were going to be subject to the 10-year bar. But then they thought about it as a family and decided that they just, couldn't keep living life like they were living anymore, and they wanted to go for it. And this is the regular way, the old way. So we tried really hard to get that interview rescheduled, but we couldn't because by that time, the National Visa Center had already canceled it. So we had to refile an I-130 all over again. And because we refiled the I-130, because that's a brand new petition, then these clients are going to be able to file the provisional waiver. But that's an unusual circumstance. So for most people who've already had a letter dated by the National Visa Center that's dated before January 3rd.
Even if the interview is not scheduled, as long as they acted on it somehow, right?
Well, I'm not sure how else they would act on scheduling an interview besides sending an interview notice. And then if it was canceled, if that's what you mean, yeah, it still wouldn't work
Right.
unless the National Visa Center had terminated their registration. They had to refile an I-130 all over again. So that's something that an attorney would have to analyze and see if there's a way around it. And then, our firm doesn't handle removal proceedings, but there are special things that have to be done if someone is currently in removal proceedings, or even if you're not in removal proceedings because they were administratively closed. And that happens sometimes when people get temporary protected status or something like that. And then if someone's actually been ordered removed, well, that's a whole nother ball game that really needs to be looked at closely to see if anything can be done to reopen those and file. Are there any questions for us?
And if you have a question, you can just type it into the little question dialog box, and we will see it on our end here.
And then, Morali, will you go ahead and scroll to the next frame so that folks listening, our email addresses are here. So if there's a question you're not comfortable asking during the webinar, or you just want to contact us individually, you're welcome to email us directly, and we'll respond to your question.
And I can say that, in this firm, Amy handles all these provisional waivers, so if you have a question, email her.
Yeah, or else he's just going to forward it to me anyway.
Exactly.
So I don't think we have any questions today.
But if you do have one later, if you think of something, obviously feel free to email us, and we're happy to help. And if you want a copy of this PowerPoint presentation, feel free to email us as well, and we'll certainly email it to you.
Okay, sounds good. Thank you so much for attending the webinar today.